Welcome back to the Peaceful Political Revolution in America podcast. In America, we the people are the constituent power, the actor which always remains outside the government, as Seyes defined it. Or, as James Wilson put it, the people are simply above their constitutions of government. The framers were well aware the people were watching. They were very clear the legitimacy of the government came from the consent of the governed. That is what made our framers revolutionaries and why our Constitution is so remarkable. But how do the people, if ever necessary, improve or replace their constitutions of government? It is true the peaceful transfer of power is the hallmark of any democracy. However, even more significant is the peaceful transition from one political system to another. All the framers understood this would be necessary sooner or later. After all, this was the revolutionary example they were leaving to posterity. It is a lesson we should not take for granted. As Americans, we should all take great pride in and be humbled by this achievement. Without the peaceful exercise of the right to establish, abolish, or simply improve our form of government, there is little left of our democracy. As Sergio Verdugo points out, however, many kinds of political actors may have a motivation for co-opting this power and for using it to their own advantage. Nevertheless, Thomas Paine, Thomas Jefferson, George Washington, and according to Christian Fritz, the author of American Sovereigns, most Americans in the 18th century believed this power was the people's power, theirs alone to invoke. So, how and why could it be taken from them, even used against them? This question remains one of the most critical questions of our time, as more and more scholars and political actors begin to assert that our Constitution is broken and should be changed, if not entirely replaced. How that is done matters. People like Mark Levin and Donald Trump think we should be afraid of our government. Stand back and stand by, for now. But what happens tomorrow? They believe the deep state is the enemy, not the Constitution. They project a dystopian vision of our society, as do many liberals on the other fringe, and the control for power is far from over. If Americans think their political system has run amok, why are they not calling for a peaceful transition to a new and improved democracy? After all, this is what the framers did, and it is how our democracy was intended to work. The question of legitimacy is the first and last question we must answer. Who has the power to alter and replace our basic law? And how does that power organize to express itself so that Americans might agree to establish a new constitution and replace our broken political system with one that works? In their recent op-ed in the New York Times, Samuel Moyn and Ryan Doeffler argue that our Constitution should not be reclaimed, and that we should also reclaim America from what is referred to as constitutionalism. These ideas and these terms are not all that familiar to most Americans, yet they are the sort of ideas and words that may empower America to become a full and effective democracy. Samuel Moyn is Chancellor Kent Professor of Law and History at Yale University. He received a doctorate in modern European history from the University of California, Berkeley in 2000, and a law degree from Harvard University in 2001. He came to Yale from Harvard University, where he was Jeremiah Smith Jr. Professor of Law and Professor of History. Before this, he spent 13 years in the Columbia University History Department, where he was most recently James Bryce Professor of European Legal History. He has written several books in his fields of European intellectual history and human rights, including The Last Utopia: Human Rights in History, humane, how the United States abandoned peace and reinvented war, liberalism against itself, Cold War intellectuals in the making of our times, and not enough, human rights in an unequal world. Samuel, welcome to the Peaceful Political Revolution in America podcast. It's great to have you join the conversation.
Thanks for having me.
We've been talking about inequality in the last several episodes because it's become real clear to me that if a democracy is based on equality, we're not doing too well. Here in the Western Hemisphere, I guess you might say Canada is doing about as good as anyone.
Right.
It's flabbergasting to me that Brazil, the United States, India, these very populous democracies are struggling with that.
Right.
Then I'm thinking, what does the Western Hemisphere have to show the rest of the world if we're struggling with that?
Absolutely.
What have we accomplished? It's really amazing to me. You have published an op-ed in the New York Times called "The Constitution Should Not Be Reclaimed." I've got a ton of questions about this because it goes to the heart of the subject in this podcast. You mentioned Jedediah Purdy.
Yeah.
He wrote a piece called "The Left's Guide to Reclaiming the Constitution," which argues progressives should say what they believe the court should do and what they believe the Constitution means. You say the real need is not to reclaim the Constitution, but to reclaim America from constitutionalism. So I wanted to start there. What do you mean by that?
Well, so, in my lifetime, which began about 50 years ago, the court has been trending right. And that's because Richard Nixon got 4 appointments. And yet, when I took high school civics and when I went to law school in the later 1990s, I was taught the kind of American mythology that civil liberties and other good things depend on a powerful judiciary, including Supreme Court. And it just seemed over the years to me that liberals had not gotten the memo that the court has been reactionary for most of history, with this evanescent exception of the 1960s. Then it's been trending right for the past half century. And the response has generally been to idealize not just the court, but the Constitution, and to say that if only we could get friends back in high places, like during Earl Warren's chief justiceship, American democracy would work out. And I guess my response is that we should acknowledge just how bad the Constitution is and our constitutional traditions, and recognize how exceptional even the very modest kind of alternative that the Warren Court provided was. And so once we do both of those things, then I don't think we can go back and say, well, if only the judges interpreted the Constitution the way it really is. We have to stare in the face that it's bad and not rely on judges to kind of fool the American people into believing otherwise. And so I am actually a good friend of Jed's, and the op-ed that we're talking about was actually written against some other friends named Joseph Fishkin and William Forbath, who have a great new book out called The Anti-Oligarchy Constitution. What these people share in common is they think that the only viable strategy in America is to pretend the Constitution is on our side. Well, guess what? It's not on our side, and it's not the only strategy to pretend it is. And so we wanted to say in the op-ed that we should change our tune.
That's a powerful statement, and one which I agree with. And I was listening to the conversation in the Senate yesterday about ethics reforms in the court.
Right.
And, nobody wants to touch that that football's too hot to touch. I get the argument that there are, two sides to the political spectrum here, and they could be abused, so the court has to be cautious about that sort of thing. But nobody's talking about term limits. What's going to hold the court accountable if it's not going to be ethics reform or something having to do with term limits, a veto, some sort of I guess we can impeach. I don't know when the last time that happened was. It was
really long time ago, and I think it happened. It happened once, although Abe Fortas was kind of driven to resign because people made a stink around some things he did, and it didn't reach impeachment.
The argument would be, if you want an independent judiciary, they shouldn't have to be accountable. Is that an argument? I don't know.
It is an argument, but it's a very bad one because, the point of the judiciary is to apply Congress's laws, the people's laws that the people's representatives have made. So the idea that we'd want so independent a judiciary that, leave aside these ethics issues, the judiciary could kind of reinvent the legal order without being challenged is insane, because these people weren't elected to make the law.
Right.
They were appointed to serve Congress. Now, I do think there's a defensible form of judicial independence, which says we don't want Congress to tell judges how to rule in particular cases.
Right.
But when judges over our history have arrogated so much authority to actually do Congress's job, writing the law, that's beyond the pale. So we need reforms. I don't think ethics reforms are even the best place to start unless they're a stepping stone, because that's just about keeping these very horrendous forms of conflict of interest from happening or punishing them if they happen. But the trouble is ideology, that, judges, when they're given so much power to interpret the law, unchecked power, will follow their ideological dictates without needing to be paid off by anyone and remake the law in their image. So that's what we need to check. And there's a big debate about how precisely to do it.
It reminds me of a documentary I saw recently called The Power of the Fed. They were talking about the failure of the legislature to regulate the banks.
Right.
And instead, the Federal Reserve steps in and
Correct.
So you have, I think it is 7 people who are determining the policies for the entire country.
Very similar. Very similar. The at some point, kind of, it was believed that kind of experts, trained elites could do better, and in fact needed to be insulated from the ordinary people's beliefs and opinions in order to have a well-run system. And the empowerment of central banks across the world, not just in this country, occurs on the same timeline as the transfer of authority to unelected judiciaries.
Wow. And
if these people have the goods, that would be a different thing. But from where I sit, you have elite misrule, endless war, economic neoliberalism, conservative hijinks on the Supreme Court. And I don't have any reason to believe that these people know what they're doing. And so there might still be an argument, even if they knew what they're doing, that we should allow democracy to work and make mistakes that maybe elites at times wouldn't make. But it seems like our problem is that elite empowerment is a recipe for mistakes. And so why think that democracy would do worse?
They have a long history, a long record of mistakes, right? So look, the level of inequality, which we have been talking about, is
absolutely,
essentially the result of these policies over decades.
That was chosen. Now, in fairness, it was chosen also by the Democratic branches, like the American people elected Ronald Reagan. But they could correct that mistake. Whereas when it's up to the central banks or the Supreme Court, which is also a very neoliberal institution, very business friendly, the most business friendly court in American history, or at least in a century. When power is transferred there, it's much harder to correct.
You have pointed us to the past. In your article, you say we have a tendency to look back at our Constitution. And in the last episode, Sergio Verdugo said, many nations, including the United States, are living under a myth about their founding, and that this myth is preventing them from moving forward as a nation. It sounds similar to what you're saying. How do we overcome the myth of our founding and create a politics which is grounded in the present moment?
Well, so that is, a great question, and it's really, I think, of burning interest in a country where the founding was a really long time ago, and it was achieved by a rather different group of people that was consisted of white male property holders. So when they weren't for democracy, they were for the interests of a much smaller group of people in a very different kind of country. And the argument we make is that a big reason why it's wrong to just hope to replace the current court with a more liberal one is that we'd still be locked into constitutional law, by which I mean every question that comes up about the future would have to be litigated in terms of its compatibility with this ancient constitution. And it's not like we can't win. Franklin Roosevelt had a New Deal by engaging in a struggle against the court and claiming the Constitution for the New Deal, saying the Constitution allows what I'm trying to get done. But why bother? Why have politics be about the alleged compatibility of whatever we've decided to do now with some old piece of paper? Well, one idea is that there are these sacred limits that can't be transgressed, but we know that's a lie. I mean, we know that when innovation comes, we go beyond what our ancestors would have did allow. And we fought a civil war and we had a New Deal, both to kind of pretend that the Constitution allowed some vast departure. Why not just say that we want to change America in the future and have a debate about the propriety of living in a different way together? What does the Constitution have to do with it? Why distract ourselves with that question when the only important question is, what are the terms of life that we want to sustain, in our time, in a future with unanticipated problems and solutions? And so that's the basic argument we make in that op-ed. And it's the reason we think it's a mistake to kind of reclaim the Constitution as if it's on our side. It's been done successfully a couple of times, but most often the Constitution obstructs change and distracts us from having an honest conversation about how and whether to change.
I suspect it's because the framers, Thomas Paine and so on, they didn't leave any process in place for the people to do that. They left a very limited, very difficult process for the government to change our Constitution. But as far as the mass of people in the country is concerned, there's no plan. There's no other example other than the convention in Philadelphia that I know of.
Right.
That outlines a procedure for people to organize and ratify a new constitution. So
Correct.
without a plan in place, it's tremendously difficult to figure out how to get to where we want to go. If we want a new constitution, or if we want to replace the one we have.
Yeah. Well, I'm against that. I mean, I can explain why. Like, it's not like if you have a bad constitution, you need a good one. If I have a broken car, I might just start walking or, take an Uber instead of saying I absolutely need to go to the dealership and buy a new one. It depends on what my other options are. The moment we lock ourselves into a new constitution, we start the debate again about whether what we want to do next is compatible with it, how we replace that one. Now, it's true that most countries make it easier to innovate, amend constitutions, or replace them altogether. And that would be a step in the right direction. But ultimately, the question is, why have such a document? And that's the argument we make. Now, under the current Constitution, as you say, Article 5 says that you can have a convention. We've never done it. Or you can engage in amendments via the more familiar process, although it's extremely difficult, of having Congress take the lead in proposing them if it can reach 2/3 majority, and then having 3/4 of the states ratify them. The last important amendment was, the year I was born. So that seems unviable. I mean, it's interesting. Conservatives are proposing to have a constitutional convention, and liberals have freaked out because they think that could only make things worse if there were a convention. But, there's this other fact, which many people don't know, which is that Article 5 has what lawyers call an eternity clause. Eternity clauses say that there are unamendable provisions in the Constitution, things you can never change. Some countries, like the old West Germany, now Germany, made human rights unamendable. Like, you can't get rid of them again the way the Germans did. Our Constitution says the Senate cannot be touched. So right there, you see this, radioactive element of our Constitution. It's not that it forbids change, though it makes it so difficult. Only it's that it says there's one thing you can't change, which is this unholy deal to give small states outsized power in our quote unquote union. So, I would be for a new constitution, but why not just have statutes? That's to say, take election law, very little in the Constitution about it. And most of our election law is statute. We could just imagine having just statute. It's not that there wouldn't be rules of the game. Maybe they would be treated as sacred. It's just you wouldn't have some other kind of law that is called constitutional law that is like, requires higher levels of consensus than just a majority in Congress to pass. I'm unclear why we would need two forms of rules. These ordinary rules, like, raising taxes requires a statute. And then these super rules, which are called constitutional rules, in our case, requiring amendments. It's the case, obviously, is that we need a lot of stability, even in democracy. I'm not sure that's true, but obviously there are certain laws that are very stable, like Social Security, just a law. No one's going to change that if they want to get elected in this country. And we could imagine, getting consensus around certain rules with no need to say, oh, they're constitutional or they are super rules that are in a constitution.
You argue the past has too much influence on the present and that liberals need to radically alter the basic rules of the game.
Correct.
This is how you're suggesting they do that, by using statute.
Yeah. I mean, supposing that, Joe Manchin and Kyrsten Sinema had agreed and the Women's Health Protection Act had been passed in response to the overturning of Roe v. Wade. So that just happened in the last Congress, came within 2 votes. That was a law, and it would have proclaimed at the federal level that women have some kind of abortion right. It wouldn't have said the Constitution requires these rights. It would have said the Congress says that they're the law of the land, the same way that the Americans with Disabilities Act says that disability rights are the law of the land. Why is that not good enough? After all, I mean, in response to the idea that we need entrenched rights in a constitution, well, but that just depends on the Supreme Court to give them or take them away the way it did with abortion rights. So what's wrong with relying on Congress to give them or take them away as statute?
You know a lot more about this than I do. I'm guessing, though, that there would be court challenges to this, constitutional challenges to these sort of statutes.
Not if we gave up on constitutional law and said the sole purpose of courts is to apply the law and not to void it.
So how do we make that happen?
Well, we'd have to return the Supreme Court as a kind of apex court to its usual role. Most of its work today is just interpreting statutes. That's what it does most of the time. What we'd have to say is, in those rare cases where it throws statutes out, the part of the Voting Rights Act in Shelby County versus Holder, or Obamacare in NFIB v. Sebelius, we'd just have to say you can't do that anymore. Mm-hmm. Now, it's actually not in the Constitution that they have the power to do so. That was accreted or arrogated over time. But we could, keep the Constitution, even the horrible one we have, and get rid of this idea of judicial review. But we could also just ditch the Constitution and say, well, if there's no higher set of rules, then there's nothing to compare statutes to and find them wanting.
Right.
And so that would be my recommendation.
And I see that working out on a theoretical level. I get it.
Yep.
How do you make it happen? How do you implement that? Like, you recommend that we should find a new way of fighting using the expression of popular will.
Yeah. So any change, including amendments or a new constitution, if that's the way you want to go, requires a new supermajority.
Yeah.
And no one has, that to just magically provide. Mm-hmm. And so I'm in a debate with people about what would we do if the Democrats, say, chose to offer promises that assembled a supermajority of the kind that Franklin Roosevelt enjoyed. When he put one together, especially in the 1936 elections, when he won so big and controlled both houses of Congress by massive proportions, he chose to keep the Constitution and the Supreme Court. All he did was propose to add a few seats. And I think that was a mistake, given what's happened since. But regardless, he had a kind of moment of opportunity to do something. Now, we're not there yet. The whole point of kind of thinking big is to do so in advance of the opportunity. Where we are now, clearly, is gridlock. It's due to the Constitution, because there's not real gridlock in America. There's massive support for abortion rights. There's massive support for a higher minimum wage. The trouble is that because of the Senate and the Electoral College, you have a false representation of the American people in Congress and in the political branches. It's as if there's an illusion of disagreement just because the Senate privileges small states. The Electoral College allows minority presidents, minority rule presidents to get through. George W. Bush and Donald Trump both got a minority of the popular vote, and less than their competitors. So, we have to challenge all that. But to do so, we would need, if we're going to kind of do so according to current rules, we'd have to do so with a big supermajority. And that depends on politicians offering things that more Americans want. The Democrats have not really broken from their neoliberal ways. The Democrats were completely complicit in the rise of inequality and other bad things. And, that's why they're not popular in some other way. Now, it's true that with respect to this eternity clause I mentioned, where the Constitution says you can't change the unholy deal that was made in 1787 around the Senate's disproportionate representation of small states, we would need to kind of sidestep that clause. And in the op-ed, we actually propose that we just ignore it. One way of doing so would be to just pack the union by just creating like 50 new states. Like, what if every zip code in Washington, D.C. were made a state? Well, then we'd control the Senate. But another way would be to just say we're going to ignore the eternity clause. And, I'm not sure what alternative there is to doing so. It's illegal in a sense, but, there have been a lot of illegal things done in American history, including, people don't know this, the Constitution itself was illegal according to the rules of change that the Articles of Confederation involved. And so when push comes to shove, you don't have to stick to even constitutional rules when you need renovation. And why should we then think we need to stick to those rules?
Sergio Verdugo and others have suggested that we should not open, he calls the Pandoras Box of constitutional replacement.
Right.
Rather, he said we should focus on fixing the specific flaws in the Constitution. And you mentioned several things that we could change, and this is a pretty well-known list, including reforms to the Senate and the court, maybe getting rid of the Electoral College, and I think you said most importantly, addressing the amendment clause, Article 5, and figuring out a way to amend the Constitution, which is more realistic.
Well, I'd have to, hear more from Sergio, but my sense is that those are extraordinarily radical changes. And when it comes to the Senate, they're actually impossible under the Constitution. Like, the Constitution specifically rules out messing with the Senate, at least, how it represents smaller, less populous states. So if he's proposing to have big amendments, including illegal amendments, I'm just not sure what the difference is exactly from having a new constitution. Now, as I've said, I'd rather just get rid of the thing. So I'm not in a debate with Sergio about whether to have amendments or a convention.
I see.
I would be in a debate with him about whether to keep the Constitution or get rid of it. And, that's a good faith debate. My position is in the extreme minority, and I'd be very happy to see any of those, lesser solutions like big amendments or a new constitutional convention. But it doesn't seem, it seems odd to me if he's saying that we should do lesser things when the very things he's calling for are revolutionary. Having the amendments that would get rid of the Electoral College would be, would require massive consensus in the United States, because you need 3/4 of the states to sign off. as I mentioned, having an amendment that would diminish the role of the Senate or change it in fundamental ways is actually not possible without lawlessness. And so if he's proposing those things, he's requiring like a quasi revolution anyway. And if that's the case, then we're really in a debate about what to do when we have that amount of support for fundamental change in the country.
You're right. He did confess he's not an American constitutional scholar. He's from Brazil, currently in Madrid. But from his perspective, he just felt, I think he was saying that replacing the Constitution becomes very problematic. All kinds of things can happen and go wrong.
Of course.
And that a better option would be to be more surgical about the approach, like fix the flaws in the Constitution.
Right. But I think he just doesn't understand how even fixing flaws in America requires quasi-revolutionary politics. I mean, because if you have something that's popular enough to get 3/4 of the states on board, you've really constructed a massive supermajority in the country against the current Constitution on anything that matters.
Yeah.
And I'm just not sure I agree with him that like frequent change to the law is a bad thing. Again, I'm not for new constitutions, but Thomas Jefferson basically said we should replace the American Constitution every 18 years because why should people born, today be under the Constitution that we make, for their whole lifetimes? And many countries, including Brazil, have had many more constitutions than we have. Now, you could argue that they've ended up worse off, but that doesn't seem obvious to me.
It's not obvious to me either. Brazil is, I think, doing better in general than it was under the monarchy. It's just complicated because we're talking here about our Constitution, whether or not, obviously, it's flawed. You call it broken. You've said, it's a horrible document, really untenable political system. But if I'm hearing you right, you're saying you don't think we should replace it. Okay, so that's an unusual view. Yeah, it's hard for me to figure out.
So let me give you, so just, for background, the whole idea of a constitution is new. Americans invented it. And it was unpopular for a long time, and especially with the features ours has. And now it's almost like unthinkable that any country would not have a constitution. But consider our mother country, the United Kingdom.
Right.
Of course, they would say there that they have an unwritten constitution. Mm-hmm. But what that means is that Parliament can pass any statutes it wants, at least until recently it could. And the Constitution consists of norms that no court can enforce, but that Parliament, their Congress, can take seriously or not. And actually, for a long time, conservatives liked that system because in effect, it allowed for slowing change down rather than courting frequent revolutions in the name of new documents, like in France across their water, where there were all of these revolutions and new constitutions every few decades. And so if you imagined us returning to the British model, you can say we would have a constitution once we just trash the written one we have. But in effect, the only question would be, what is the Congress going to do next? Now, it might do nothing. It might just accept the rules that prior generations passed. But the point is that it could change them when an ecological crisis threatens, or whatever, an inequality crisis threatens. And that would then be the Constitution. So I'm for replacing the Constitution in that sense, but not with a written document. And that goes back to this conversation we had about statutes. What if the law was just the law that Congress passed until changed? What's wrong with that? If you explain, I might change my mind, but I don't know of a good answer to that question.
Right. You say it will not be easy, but a new way of fighting within American democracy must start with a more open politics of altering our fundamental law.
So that's like taking baby steps, because we could say, look, what we need to do to get to that, statutory model is to say, well, first we're going to make our constitutional order more malleable. Like maybe we keep the written document, but, see that we can change it with amendments, make amendments easier. But that's just to say that the constitutional order becomes more like statutory law, which just requires a majority in both houses of Congress and the president's signature.
The last amendment that was passed was, as you said earlier, 50 years ago or more?
The last substantial amendment, which lowered the voting age, was, I think, 1972.
Yeah. And I think 12,000 amendments have been proposed, but only 14 have been passed.
No, 27. Yeah.
Sorry, yeah,
well, the first 10 were the Bill of Rights. Yeah, exactly.
Yeah. So I'm just thinking, how does this work out? How do you really exercise the popular rule?
Yeah.
Is it just organizing through political parties? How does it work?
That's what we have now. And again, there are a couple ways. You can think in terms of using the amendment procedure, which is, again, 2/3 of the Senate and 3/4 of the states, to weaken the amendment process. Okay. So you could change Article 5 that way.
Okay.
Now, that doesn't seem viable anytime soon.
No.
So then there's this other, let's say, more surreptitious way, which is to pass a law that you want and defend it against the courts. So let's consider the Women's Health Protection Act again, federal abortion rights. What if you had Congress pass that law and say the Supreme Court cannot overturn this?
Mm-hmm.
Or you could say it requires 8 justices rather than 5 to overturn it. Mm-hmm. Various options. Well, mm-hmm. Then in effect, you've changed the law of the land. You've changed the constitutional order through statute. Mm-hmm, mm-hmm. And slowly we could use ordinary law to make kind of the Constitution less and less important, up to the point that we just there was a consensus to get rid of it. Mm. Because all that matters really is like, what are the rules? What are the rules that the courts enforce? Rather than overturn. Because the Constitution, in a sense, doesn't matter if it's not enforced. And, my take is that we can take big steps through just changing our statutes, and then defending those statutes against all comers. Mm-hmm. And that seems to me the more plausible way of proceeding.
You would advocate that the Democratic Party, I presume the liberals, take up this challenge and try to change the amendment clause.
Most days I think both parties are unsalvageable, and I voted for third parties in my life. I don't know if the Democrats are ever going to step up for freedom and equality in this country. But if they did, then, then they should. And again, they got very close on the Women's Health Protection Act. So, and they've done some things economically under Joe Biden, although I don't think we should, overpraise him or overstate how big the moves made were, I mean, just consider the tax rates, which they haven't raised in a plutocracy. So, but there, what are our alternatives? It's a new party, possibly. I mean, we're really waiting on realignment, because that's when parties see the opportunity to construct a new majority. And neither party right now is kind of like up to the challenge of doing that, but we're waiting for conditions in which one would.
Well, we're going to need some massive shifts in this country if we're going to deal with these problems are urgent. We have to deal with them in a relatively short period of time. I think
I'd like to agree with you, but the truth is that you can dither for decades, and that's what we've been doing, honestly. And so you can have gridlock for, the first Gilded Age was decades of partisan gridlock, and we're in the second Gilded Age. And you can't really say the problems demand solution, because they always did. And yet nothing can happen. So we're waiting for a kind of charismatic politician who's willing to save the country. And will that take 5 minutes or 5 decades? No one can say.
I guess I should ask you specifically, because I spoke with George Van Cleve about his book, Making a New American Constitution. He proposes that we create a national convention coordinating committee, and that committee would be charged with establishing the rules for electing delegates to a convention and raising money and awareness about the convention, et cetera, et cetera. To me, I like that idea because I find the alternative is going to be risky. I just don't trust that anything's going to happen if we don't address the Constitution and create a better, more democratic political system. And that would be my goal, just to make it more democratic.
Right.
So, what's the argument for not holding a convention in your view?
Well, it depends on the purpose of a convention. If you could do it, then you'd have the question, are we just scrapping the old Constitution and then leaving the institution of Congress standing with its current laws to keep or change? Well, then I'm for it. If the proposal is to have a new convention in order to write a new constitution, you're really dealing with this fantasy that like you could engage in a one-time fix and get the right set of rules that are binding through judges. And that's just a fantasy, because first of all, if you could get the convention, you would already have democracy, because you'd need democracy to get the convention. But more important, we're only going to have a series of partial fixes. And my take is that it's going to be much more plausible to get these big statutes through, and, get the existing Congress to just get a little rowdier than it has been in a series of steps. So, if you take like current jurisprudence, after Shelby County v. Holder, the Supreme Court is about to void another part of the Voting Rights Act of 1965. Well, what if Congress said, no, you can't? Again, that's a statute. What if Congress said, no, actually, you don't get to do that? Or take affirmative action. When the Supreme Court says that affirmative action is constitutional, the Congress could said, no, we actually are going to enact affirmative action rules and not let the Supreme Court overturn them. And then you have a big step forward. That seems a lot more plausible to me than calling for a constitution, a new constitution, when to get the thing, you're indulging in this fantasy of a convention that would agree on the right rules.
I just find that Congress is too dysfunctional to operate like you're suggesting.
Well, compared to what? You know, in any comparison, you're always at risk of what we call the nirvana fallacy, which is to treat existing institutions realistically and then alternatives in a utopian way. And that's not a fair comparison. If Congress is dysfunctional, well, so would a convention be.
Mm-hmm.
You know, in my view, Congress has some capacity. It's just not infinite or utopian. And we need to work with what we have to make major steps forward. And that seems like it's more plausible. But if George Van Cleve thinks he can generate a progressive convention, well, then more power to him. I just think, if the rules are just going to be, let's have democracy. Well, democracy is voting on people to serve in Congress to pass laws. That's what it is. Everyone gets to vote, obviously, without voter suppression. But, we don't have an institution that can guarantee that anyway. And just having it written down that we live in a democracy doesn't make it happen. So I'm just not sure. I mean, what we need is a Congress that says we're going to pass national election laws that enfranchise everyone. Now, it tried to do so with respect to certain issues in 1965, only to see the Supreme Court overturn its handiwork in our era. So why not just, acknowledge that what we need is our legislators to own democracy, not to have a piece of paper that says we are one.
On that topic, I've been talking to people like Aaron Lippert, Dean Stephen Taylor, about electoral systems and how ours is pretty insufficient, undemocratic, really. So I agree with you. It would be great, for example, if we could pass a statute that said all of our elections are going to be run by proportional representation, for example. That would end gerrymandering, and it would create a multi-party system overnight. That would be a pretty good solution to the problem, I think.
It's consistent with my view that the way ahead is for Congress to pass laws, in this case, federal election laws, and then face down the Supreme Court. The Federal Election Commission imposed limits on campaign contributions, and in Citizens United, the Supreme Court said you can't because the Constitution forbids it. And that's just a case of judicial legislation. So this proposal to have national election laws is just consistent with the, solving the real problem, which is to have any laws that Congress decides it wants. We have to, face down the Constitution as imposed on the country through the interpretations the Supreme Court makes of it. And this would be an example. And then if we had a system of statutory law, we'd be in a debate about, well, what kind of election laws should we have? What should the districts be? Should we continue to have states? Should there be 50? Should there be 400? Should there be 435 people representing hundreds of millions, or should there be 1,000? All of these are, things that we'd have to work out. But the question is, who gets to make the rules? And right now, the answer is, 5 of 9 old people.
Christian Fritz has a new book called Monitoring Federalism. He explores the genesis of interposition. I wanted to get your thoughts on that because he writes, Hamilton and Madison responded to opponents of the Constitution, arguing state legislatures were uniquely situated to be the voice of the people, who would sound the alarm if the general government exceeded its rightful authority. So legislative acts are not the same as procedures of popular will, I take it. So how are they different, and are you in favor of one over the other? Because we're talking here about the exercise of popular will.
Sort of. I mean, this is the paradox of democracy, that the people rule, allegedly, in a democracy, but no one knows what they think. The people have to be represented, and institutions have to be chosen to reflect the popular will, for better or worse.
Right.
Then we'd be in a debate about, well, which institutions? And we could argue that, we should have representative assemblies like Congress, or we could argue that we should have plebiscites or referenda where the whole body of the people is asked to come decide on a matter. Now, Fritz's idea sounds incredible to me, just because the states are more undemocratic than the federal union. Many states. Actually, the judges in many states have more democratic credentials than the state legislatures because of gerrymandering. I don't have any reason to believe that states should be given more authority just because they historically existed and because the Constitution was a kind of treaty amongst states. Very few people, identify strongly with their location on planet Earth anymore. And certainly, Americans are organized currently by these state lines, but many people move a lot or identify according to a host of other criteria. So, the idea that we would, in a sense, go backwards and, rely more on states as representative, credible representative fora than the federal union strikes me as like a serious mistake.
Yeah, it's interesting to hear you say that. We'll have to see where it goes.
Fritz's book speaks to the role of state legislatures in, as the title says, monitoring federalism.
Yeah.
So it's a little different.
Many of these state legislatures barely meet because they've been designed not to represent the people of their states, like in Texas. And I'm from Missouri, and I think, federalism has been a disaster and really state-based identity. So I'd much prefer to see a new order, call it constitutional if you want, that just abolish the states altogether.
I like it. What would you recommend for our first step towards reforming our political system or our politics, whatever? What to you is the priority?
So, I mean, you could start in many different places, but I do think that safeguarding federal law from the courts is an imperative. And that's, true, especially or most flagrantly when the courts say that laws are unconstitutional. And so I think we need some experiments where Congress tries to protect its laws from the courts, and there's precedent for this. And, there are a lot of options. I mentioned the supermajority rule, which would say that the women's health protection requires 8 justices rather than 5 of 9 to be overturned, which makes it harder to overturn. Right. But something like that strikes me as a good first step, because then we can repeat it with future legislation when there's, a big enough majority to support it.
There was an article someone sent me the other day about the ERA, the Equal Rights Amendment, languishing in Congress. It's, dead on arrival at this point, isn't it?
Well, there's a debate about that.
Yeah.
You know, again, that's an amendment, and if you didn't have a constitution, you wouldn't need to amend the Constitution. You would just have ordinary law passed for women's rights. So like the Women's Health Protection Act is a good example. Mm-hmm. And it gives substance to what it means to be a female citizen of the United States, by just changing the rules and not like having a 50-year campaign to change the Constitution.
Wow. Well, those are great ideas. Thank you so much, Samuel. It took a while, but I think it's finally sunk in. This podcast has been about our Constitution and how Americans might improve or even replace it with a more effective and more democratic political system. Samuel Moyn and Ryan Doeffler argue this would be unnecessary if we simply rewrote the rules and protected them from judicial review. They make a powerful argument for not wasting our time on constitutional windmills. They say it would be better just to throw the whole thing out. I still have questions about their proposal. Can we simply ignore our Constitution, restrain the courts from interfering with the role of Congress, and establish new rules for America by enacting statutes using procedures of popular will? Deference to our founding document is essential to our democracy, but mystical devotion is not. Tune in next time for more perspective on the need to rewrite our Constitution when I talk with John Harris about his September 22 article in Politico, "The best way to save the Constitution from Donald Trump is to rewrite it." Until then, stay safe out there.